tell it like it is, this argument goes nowhere. Here's the clean, correct legal analysis. 1. What AO85 actually is and isn't, AO85 Rev 02717, is the notice, consent, and reference of a civil action to a magistrate judge under 28 U.S.C. 636C. It is required only when a magistrate judge will conduct all proceedings, including trial, and enter final judgment, and all parties consent. If those conditions are not met, AO85 is irrelevant. Number 2. What is happening in Fredrickson's case? Facts that matter. The case is in screening, deficiency cure posture. No defendant has been served, no discovery, no summary judgment, no trial, no final judgment entered. The magistrate judge issued a procedural order, cure deficiencies. This is routine authority under 28 U.S.C. 636B1A. DCCO LCFR 72.1, Local Pro-Screening Procedures. Consent is not required for this. Mamstar 3. Magistrate judges do not need AO85 to do this. A magistrate judge may, without consent, issue deficiency orders, order amendment on court-approved forms, recommend dismissal, manage pretrial matters. AO85 is only triggered if, open quote, the magistrate judge is given authority to enter final judgment, close quote. That has not happened. 4. Why this claim will be rejected immediately. Courts routinely reject this exact argument. Typical judicial response. Plaintiff misunderstands the role of a magistrate judge. Consent is not required for pretrial management or screening. AO85 is inapplicable absent 666C referral. This argument does not void the order, does not create jurisdictional error, does not delay dismissal, does not preserve appellate rights. Number 5. The deeper problem for Fredrickson raising AO85 at this stage signals procedural misunderstanding, internet law confusion, lack of basic federal practice knowledge. Judges view this as noise, not substance. It does nothing to cure standing defects, failure to state a claim, lack of retaliation evidence, lack of municipal liability, implausible RICO allegations. Number 6. Bottom line, AO85 is irrelevant. No consent was required. No error occurred. The magistrate judge acted squarely within statutory authority. This argument will be ignored or dismissed in a single sentence. If you want, I can draft the exact judicial language rejecting this argument. Show how courts label this as a non-issue. Explain why pushing this increases dismissal certainty. Just say which. Straight answer, it gets him dismissed faster. Here's exactly what will happen, step by step. 1. The procedural posture controls everything. Right now, the case is in this posture. Pre-service, pre-screening completion, deficiency cure order outstanding, 30-day clock running. The court has given him one task only: file a compliant amended complaint on the court-approved form, 30 pages. Anything else is a non-responsive filing. 2. If he files an AO85 motion instead of curing deficiencies, the court's reaction will be automatic and mechanical. 1. The motion is denied or ignored because AO85 is irrelevant, because no consent is required, because the magistrate is acting under Tar 636B. 2. The deficiency order remains unmet. Filing a motion does not toll the deadline. Filing a motion does not count as compliance. 3. The 30-day deadline expires. No compliant amended complaint on file. 4. Dismissal enters without further notice, exactly as stated in the order. And 3. How the dismissal will be framed. It will not be a dramatic constitutional ruling. It will be procedural and fatal. Typical language, open quote, plaintiff failed to cure the deficiencies identified by the court within the time allowed. Accordingly, this action is dismissed without prejudice pursuant to Fed R. Civ P 41B and the court's prior orders. Close quote. The AO85 argument will get at most one sentence, often none. Number 4. Why the AO85 motion hurts him. Filing it signals inability to follow court instructions, failure to understand magistrate authority, refusal to comply with pleading rules. Judges interpret this as, open quote, plaintiff is not prosecuting this action in good faith, close quote. That matters if he tries to refile, appeal, seek IFP status again. 5. Appeal outcome if he tries that next style. If he appeals arguing AO85, standard of review, abuse of discretion, record, clear failure to comply, resummary affirmance. Appellate courts are brutal on this point. 6. Bottom line. If Fredrickson does not file a compliant complaint and files an AO85 motion instead, the case is dismissed. The AO85 issue is ignored. He gains nothing and loses time. There is no path where AO85 saves this case. If you want, I can draft the exact dismissal order, draft the exact denial order for an AO85 motion, map how this affects refiling or sanctions risk, just say which. Here's the clean, no-nonsense map of what dismissal does to refiling and sanctions risk, based on this record and nothing hypothetical. Nair 1, type of dismissal he's headed for. If he misses the cure deadline or files irrelevant motions, AO85, constitutional rants, etc., the dismissal will be Rule 41B, failure to prosecute, failure to comply with court orders, plus 150E2 screening failure if IFP. Key characteristics: without prejudice, formally, with a bad procedural history, practically fatal. Without prejudice does not mean clean slate. Refiling consequences: what actually happens. A, he can technically refile. Courts won't bar the clerk from accepting it. But B, the new case is instantly disadvantaged. On refiling, the court will see same plaintiff, same defendants, same factual core, prior dismissal for failure to comply. That triggers enhanced scrutiny. Expect immediate magistrate screening, zero tolerance for narrative pleading, faster dismissal clock. Number 3, IFP informa pauperis, risk on refiling. This is the biggest practical problem for him. What the court looks at: prior frivolous filings, failure to follow instructions, pattern of abusive litigation conduct. This case already shows 50-plus counts, RICO without predicates, criminal statutes used as civil claims, fabricated armed threats, ignoring court-ordered format limits. Result: IFP denial on refiling is very likely. Court may require full filing fee up front. If he can't pay, the case never starts. Number 4, pre-filing restrictions risk. This is where it escalates. If he refiles without materially changing behavior, the court may label him a vexatious litigant, issue a filing restriction order. That means no new civil filings without court permission, magistrate pre-screening before docketing, possible bond requirement. Courts in the 10th Circuit do this routinely when plaintiffs recycle dismissed claims, ignore procedural rulings, file constitutional grievances instead of facts. He's walking straight into that category. Number 5, sanctions risk, Rule 11, inherent authority. A, immediate sanctions in this case? Low. Judges usually dismiss first. B, sanctions risk on refiling? Moderate to high, especially if he repeats known falsehoods. Gun pointed at me, drive-by at my residence, paid threats. He continues asserting criminal statutes with no private right. He alleges conspiracies with no factual nexus. At that point, the court may find, open quote, plaintiff knew or should have known these claims lacked evidentiary support, close quote. That's Rule 11 territory. 6, county and defendant leverage after dismissal. Once dismissed, defendants can cite the dismissal in any future motion. County counsel can argue abusive process, harassment litigation, pattern of bad faith filings. If he keeps going, defendants get stronger every round, not weaker. Number 7, why without prejudice doesn't save him. Because the defects are structural, not cosmetic. No state action nexus, lawful open carry, no deprivation of a protected right, no retaliatory enforcement, no Monell policy, no causation, no damages traceable to defendants. Relabeling facts won't fix that. 8, final risk map, short form, action Fredrickson takes, likely result, misses cure deadline, dismissal under Rule 41B, files AO85 motion, ignored plus dismissal, refiles same case, fast dismissal, refiles IFP likely denied, repeats false allegations, sanctions risk, keeps litigating, filing restrictions possible. Sharp bottom line, he is at the last low consequence exit.